When two business partners decide to split everything equally, they face a unique challenge. Equal ownership means equal power, but it also means equal potential for conflict. Understanding how to structure a 50-50 partnership agreement can mean the difference between a thriving business and a costly stalemate. A 50-50 partnership contract is an agreement between two or more business partners where each party holds an equal share in both profits and losses. This type of agreement outlines each partner's responsibilities, establishes rules for the general partnership, and determines how profits and losses will be distributed. These agreements are also known as articles of partnership, business partnership agreements, or general partnership contracts. Under a 50-50 partnership, each party has an equal say in the operation and management of the business. Partners can dissolve the partnership at any time. Contributions to the business can vary significantly between partners. For example, one partner might bring business management skills, while the other provides the capital to finance operations. The agreement is structured around these different types of contributions. Several key terms must be included in a 50-50 partnership agreement. The agreement should specify the name of the partnership, each partner's contributions, each partner's authority to make binding contracts or debts, and each partner's specific duties. It must also outline how disputes will be resolved and how decisions will be made. An equal split doesn't require identical contributions. One partner might cover 100% of the credit line, while the other provides 100% of the real estate. Regardless of the percentage breakdown of contributions, each partner shares 50-50 in any profit or loss. One of the most crucial aspects of a 50-50 partnership is establishing a clear decision-making framework. Since each partner holds equal power, deadlocks can easily arise. To prevent this, the agreement should include defined authority levels for various business decisions. For instance, one partner might be authorized to approve purchases up to $5,000 without requiring consensus from the other partner. The agreement should also establish a structured meeting schedule where decisions are discussed and documented. A tiebreaker mechanism is essential for resolving stalemates. This could involve appointing a trusted third-party advisor, implementing a rotating lead partner role, or designating a neutral party to cast the deciding vote when partners cannot agree. Without these systems in place, unresolved disagreements can lead to business paralysis, financial losses, or forced dissolution. The buy-sell portion of a 50-50 agreement serves an important function. This section states the terms and conditions in the event of a buyout, resignation, retirement, divorce, or death. It ensures that the partnership will continue as originally designed. Without this portion clarifying the terms, the partnership will be dissolved according to state law and the Uniform Partnership Act. A strong 50-50 partnership agreement must include contingency plans for various scenarios. This includes trigger events such as death, disability, bankruptcy, or misconduct. The agreement should specify valuation methods to determine the price of a partner's share, whether through a formula like an EBITDA multiple or through third-party appraisal. Right of first refusal clauses give the remaining partner the first opportunity to purchase the exiting partner's stake before outside parties are involved. Mandatory buyout provisions prevent scenarios where an inactive or disruptive partner holds up business progress. A special allocation occurs when a disproportionate distribution of profits or losses is written into the 50-50 partnership agreement. For example, one partner might receive 70% of the business's profits, while the other partner receives 30%. While special allocations allow flexibility, they must be carefully structured to comply with IRS rules and avoid unintended tax consequences. Important tax considerations include whether the partnership is taxed as a general partnership or an LLC, whether the allocation has substantial economic effect as required by the IRS, and understanding self-employment tax implications. Partners may be responsible for paying self-employment tax on income, regardless of distributions. Setting aside reserves for estimated tax payments is especially important if one partner handles more day-to-day finances. There are several pitfalls to being involved in a 50-50 partnership. It's not unusual for one partner to contribute an unequal share of money, credit, assets, time, or other resources necessary to run the business. Important business decisions are often delayed when partners fail to reach an agreement. Partners often reduce the possibility of deadlock by allocating a small percentage, such as 2%, to an unbiased and trustworthy third party who would cast the deciding vote should the partners not be able to make a decision. If the court steps in because a 50-50 partnership cannot reach a material agreement and business comes to a halt, the company's assets will be liquidated. Common issues that can cause 50-50 partnerships to falter include unequal effort versus equal reward. When one partner consistently contributes more time or effort, resentment can build if profits are shared equally. Personality or value clashes can create conflict when partners have different leadership styles or business ethics. Poor communication allows problems to fester and leads to distrust. Lack of flexibility can harm the business long-term if roles or terms become outdated and partners cannot adapt to change. A 50-50 partnership requires input and consent from both partners to build the business. Trust is a vital factor. Without trust, conflicts will arise. Prior to signing the agreement, partners should hash out the goals of the business, the commitment level each partner has, salaries, and how the dissolution of the company would proceed. Each partner must have access to all company property regardless of each one's assigned tasks. Having a dispute resolution process that is fast and efficient is essential. If this is not part of the agreement and a legal dispute arises, it can be very costly. When a dispute arises, whatever resources are used to resolve the conflict should be kept to a minimum. This will lessen the impact on the business while saving time and money. Mediation is another option to consider when a dispute arises, potentially allowing the partners to move ahead without being bound to the original agreement. Each partner needs to set reasonable salary expectations, and both partners need to agree about each other's salaries. Some characteristics consistently show up in thriving 50-50 partnerships. These include aligned long-term goals and complementary skill sets, mutual respect and trust both personally and professionally, a culture of accountability where each partner owns their responsibilities and delivers results, and clear documentation ensuring nothing is left to assumptions or verbal agreements. A 50-50 partnership agreement grants equal control and financial interest to each partner, making the decision-making structure critical. Defining roles, responsibilities, and dispute resolution mechanisms can prevent deadlock. Strategic planning for profit sharing, contributions, and partner exit strengthens long-term viability. Appointing a tiebreaker or neutral advisor is a common strategy to resolve impasses. Trust and aligned goals are foundational for success in a 50-50 partnership. Having an experienced attorney draft the agreement ensures it is legally enforceable, tax compliant, and tailored to your specific business situation.